still on? I hope so. Heather, we will be recording this. Yep. This is a time set for oral argument in Jackson versus Trans-States, our case number CV 20-0018. Counsel, good morning. We are proceeding via Teams, as we've talked about. In a different world, you'd have a delightful courtroom with a great podium clock. Each side has 20 minutes, and you'd be able to keep track of your time on that courtroom clock. Instead, I'm using my smartphone clock. Mr. Wilmer, if you want to reserve a portion of your 20 minutes for rebuttal, feel free to do so, but you need to keep track of your own time. I will be the official timekeeper here, and I'll let you know if you do wish to reserve how much time you have left after your opening presentations. Proceedings are being recorded. Pardon me. Please tell us when you begin your presentation, your name and the party that you represent. Also, please understand that we have reviewed the case. We're familiar with the record. We've conferenced the case, and we would encourage you to keep that in mind as you present your argument to us today. With that, Mr. Wilmer, you may proceed.
Thank you and good morning. May it please the court, Tom Wilmer for the petitioner, Ms. Jackson. I'm not here to make new law. I feel more like I'm an NFL coach who's throwing his red flag out on the field, asking the home office, meaning you, to review a call made by the referee, which in this case is Judge Steiner, who was a new judge, pretty much a new judge at the time this happened. As reflected in my papers, my client had a condition. She was getting treatment, actively treating, and around the time of her initial hearing, she had been sent to her family doctor, sent her to Dr. because he was concerned that she had a frozen shoulder. When she testified, she had yet to see Dr. Letterman, but did say that she was scheduled to see him. And as referenced in my opening brief, you have the transcript. There was discussion about, hey, Judge, let's hold off a little bit. My client's going to have an MRI. You can see that. You know, what he finds at surgery may be very, very important to of the hearing, i.e. continuing benefits. I need more medical treatment. Well, I cannot explain Judge Steiner's reasoning because there really is not any reasoning set forth in her correspondence that denied the request. She made no findings with respect to that in her award, so I can't tell you what her mindset was. But what I can tell you is that we are in the exact situation that the court in Amy predicted. She refused the additional evidence. She ruled on what she had. I had to file a petition to reopen, which was denied. And because of my concerns about finality relative to this decision, I had to file an appeal. And in doing so, I'm pretty certain that, you know, the case law is not super clear, but I'm pretty certain that that divested the commission of jurisdiction with respect to the question of continuing benefits, i.e. need for treatment. So as it stands, here we are. We're kind of stuck in time. I really can't do anything further until this decision gets decided, and hopefully the matters get remanded back to the ICA so that we can conduct hearings where Dr. Letterman can testify about what he observed at the time of his surgery, which has been accomplished. So really, like I said, you're the home office, and there's not much more I can say to you. I'm the coach. I throw the flag out on the field. I can't get on the guys and say, hey, look at this particular shot. Look at this particular shot. This is really up to you. And as I said, we are in the exact situation that the court in Amy predicted. The situation the court in Amy should be avoided. In this case, the only hearing that had taken place was the initial hearing for my client's testimony. We had not scheduled further hearings for the doctor. So here, my position is that, okay, let's hold off, get the surgery, let's recircle, and then decide at that point how we're going to proceed. So I really don't have much more to say other than what I've said so far. So I'll reserve my time.
Very well. I do have a question or two, and let me look to my panel mates to see if they do as well. But Mr. Wilmer, we're here on an abuse of discretion standard of review, correct?
Right.
And in Amy, and I understand that you've presented that as the closest case to something like this. But Amy, there were subpoenas that weren't honored, right? That actually, or at least a subpoena for a doctor that wasn't honored. That didn't happen here, right?
Well, I'm trying to remember. I think in Amy, it wasn't a subpoena. It was a doctor wanted to testify, the treating physician, and he missed his initial hearing. Then prior to, and I'm working off my memory here, so forgive me if I'm wrong, but I think immediately prior to his testimony, once it was rescheduled, his patient, the worker, had been sent to a facility for treatment. I think she had an emotional issue, and under that circumstance, the defense objected and says you can't present this evidence, and that was the underlying fact.
But let me ask, and Amy, to use a bad term speaks for itself. Although I did recall that the doctor had been subpoenaed there. Here, the doctors that you were not allowed to call were not subpoenaed, correct?
That's true. That's true.
Go ahead.
I'm sorry. If you look at the discussion at the time that followed the initial hearing, that's where I say, hey, Judge, when my client testified, her saying I'm scheduled to see Dr. Letterman, that was a new revelation. And, my discussion to the court was, let's just hold off. And let's hold off. Let's get her evaluated and let's regroup. Now, Mr. Baker is going to complain that, well, I'd have to get a new IME. His IME was stale anyways. It was the IME that he had was done in November of 18. So, it would not be prejudicial to him to say, okay, let's hold things. Let's see what Dr. Letterman has to say. Have your experts look at it and comment accordingly.
Well, and an implication of abuse of discretion standard review is the ALJ could have ruled the other way, right? And meaning the appeal never would have been taken, and
Right.
And all the things or some of the things that you described would have happened, but that didn't happen. And the question is that erroneous? And that's what we're asked to say, as you point out. One other question, though, that I have, and I think that's it for now for me, is what if, we understand if the award, if the court sets the award aside, but if the court doesn't set the award aside, what's the effect on your client? Is your client, precluded from going back to the commissioner, or would that sort of end the inquiry?
Well, I think Baker would agree with that. He's going to say, you're stuck with this decision. The Judge Steiner is stationary. My experts, she has no condition or.
Mr. Wilmer, let me ask you if you could sort of repeat that. You're cutting out a little bit, and I want to hear your answer.
Okay. Is that the firm's here, and we go back down to ICA to petition to reopen, Mr. Baker is going to argue that is bound by issue preclusion. His was adopted by Judge Steiner in the stationary, and the basis for that is that it wasn't related or we couldn't find anything, what have you. That's what his position is by Judge refusing to just push things off later surgery, because the best evidence is what a doctor sees when surgery. Right, scans are not, especially in shoulder cases. So, to me, that's where if the court affirms here, I'm bound by Judge Steiner's ruling. My petition to reopen is basically fail, in my view.
Thank you. Let me look to my panel mates if there are any questions for you. All right. Now, I see none. By my clock, you have about 12 minutes left, although the court always encourages brevity and appreciates that. But Mr. Baker.
Yes, thank you. May it please the court, Steve Baker for respondent Trans State Airlines and Starr Indemnity. Thank you for granting us oral argument. We appreciate it at the Industrial Commission. The simplest theory when there's competing theories is usually preferred over the complex theory. And in this case, we don't need to get into a discussion of Amy. We certainly can if you would like to, but in my opinion, Amy does not apply. I think what applies is Rule 41, which provides that an administrative law judge shall not continue a hearing because a witness fails to appear unless a subpoena was timely requested for that witness. In this case, subpoenas for Dr. Letterman and Dr. Houston were not requested before the initial hearing, and I submit that if you review the hearing transcript carefully and the letters that were done after the initial hearing, you will see that applicant never committed to having Dr. Letterman or Dr. Houston testify. The idea was to postpone the hearings, that is, continue the hearings, and she might call Dr. Letterman. She might call Dr. Houston. Well, I don't think the rules work that way. I think before the initial hearing, you have to have worked your case up and you have to have identified who your expert will be. In this case, she elected to go with Dr. Scott. She had already seen a Dr. Harmson, who's a board certified orthopedic surgeon who specializes in shoulder surgeries. She'd already seen Dr. Houston, who's a physiatrist who does treat cervical injuries. And she did not request a subpoena for either Dr. Harmson. She didn't request a subpoena for Dr. Houston, who she'd already seen, nor did she request a subpoena for Dr. Letterman, who was in the same office as Dr. Harmson at the time, TOCA. Amy doesn't apply, and I don't mean to be redundant, but because in Amy, there had been a timely subpoena request for Dr. Mennick, who was the psychiatrist the applicant was relying on. Dr. Mennick, because of a scheduling error, did not show for the initial hearing. Before he could testify, the applicant had been hospitalized and was seen by Dr. Mennick, and he was precluded from testifying regarding what had happened to the applicant before he had most recently seen her. And the court didn't rule that that evidence has to automatically come in, but the judge has to exercise discretion in determining whether or not it does or does not come in. But again, in this case, no subpoena request was done for the witnesses the applicant requested that the hearings be continued for, so that additional medical evidence could be submitted. Page 391.
Mr. Baker, let me
Yes.
ask you, if the ALJ denied the request, and that resulted in additional time, and that resulted in this appeal, if the ALJ had granted that request, would that have been error or abuse of discretion?
I believe it would have been, Your Honor, and the reason I say that is not because of Amy, but because of Rule 41. I don't think the judge has discretion to continue hearings over objection for a witness for whom a subpoena has never been requested. And I'm looking at Rule 41, and it says an ALJ shall not continue a hearing because a witness fails to appear unless a subpoena was timely requested.
And
So
I understand that, but that's a somewhat different issue, right? Because there's no argument here that the witness has failed to appear. It's whether, hearings should have been set off into the future where subpoenas hadn't issued. So I understand your reliance on Rule 41, but I'm not sure Rule 41 addresses the question that I am pressing, whether the ALJ would have erred in granting the request.
I haven't considered that issue, and that issue's not before you. My best estimate is that if she had elected to hear testimony from Dr. Letterman, I probably would not have a basis to appeal. I think she could exercise her discretion in either way. I would have appealed. I would have argued that I had been prejudiced. Whether or not I would have prevailed, I don't know. I think the judges are given a lot of discretion in running their courtrooms. And I think the proper thing for the Court of Appeals to do is, in most instances, defer to the judge's discretion in the running of their courtrooms. I mean,
and I understand, and that's sort of how it works, be it administrative or judicial. Let me ask you though, and again hypothetically, if the ALJ had granted the request, what prejudice would there have been to you and your client?
Certainly, and the prejudice one is the IME report that is now stale, having to spend the time to get the additional records, having to spend the time providing them to my experts, obtaining additional reports from them. The longer a case goes on, the higher the defense costs are, the higher the costs are to the clients. So without a doubt, there is monetary prejudice to the defendants, and there's a reason why we have these procedural rules. And the reason is to keep the hearings moving. It's supposed to be a cost-effective system. It's supposed to obtain substantial justice, but within the parameters of the rules.
Let me ask you though, the prejudicial items that you mentioned, let's say that the subpoenas were timely issued and the doctors were timely noticed and called, you would have to do all those things, perhaps with the exception of the IME report being updated, and let's set that aside for now. You would have to do that if they were timely called, correct? Well,
except for the fact that you're assuming that they would have been timely subpoenaed and not have done the treatment they were recommending before the initial hearing. I think one of the things is an obligation, for example, in this case, to move forward to develop your case before the initial hearing. Instead of seeing Dr. Letterman, instead of following up with Dr. Harmson, she made the decision to see an IME physician, Dr. Scott. She elected to go with that expert as opposed to working her case up with Dr. Letterman, which is what she should have done if she wanted Dr. Letterman to testify. She claims poverty, and yet she was able to get in and pay for a $1,500, $2,000 exam with Dr. Scott. That money could have been spent to follow up with Dr. Harmson, who's a shoulder specialist, follow up with Dr. Houston, who's a cervical specialist, obtain the diagnostic studies, determine if she was or was not a surgical candidate. Remember that she had already been worked up significantly. She'd seen a Dr. Greenfield, who was a board certified orthopedic surgeon. He told her she wasn't a surgical candidate. She'd seen Dr. Harmson. He seemed to think that she needed conservative care, but he was recommending active care. She'd seen Dr. Houston for cervical complaints. She'd seen Dr. Scott for an IME. She was able to accomplish all of that before the initial hearing, and yet wasn't diligent enough to see Dr. Letterman, obtain the MRI before the initial hearing. The idea is that we're supposed to do these things as cost effectively, these hearings as cost effectively as possible. There has to be an end at some point in time to discovery. There has to be an end at some point in time to the hearing process. And I think ultimately applicant's counsel has waived many of the arguments he wishes to make in this case, because he stipulated before Dr. Scott testified that in fact we would not consider medical evidence garnered after the initial hearing. The judge never ruled that medical evidence after the initial hearing could not be considered. The only thing she did was say, no, I'm not going to continue these hearings indefinitely. I am not going to take testimony from witnesses for whom you've never requested a subpoena. Nothing precluded the applicant or myself from getting the records from the treating physicians and providing them to the experts for their review and comment. And as I point out in my brief, under Rule 703, that's entirely appropriate. And it happens all the time at the Industrial Commission. You identify an expert to testify, additional evidence is developed after the initial hearing by other physicians. You provide that to your expert. Your expert says, based upon this corroborates my opinions. Here's why. Based upon this, my opinions remained unchanged. Here's what those doctors found. Here's what I considered. For strategic purposes, applicant's counsel elected to waive the right to present that additional medical evidence. And I think by doing so, waived the argument that the judge ruled erroneously in not continuing the hearings. Keep in mind, she had surgery, so she sees Dr. Letterman August 20th. She sees Dr. Letterman August 13th. She sees Dr. Letterman in August, has the MRI August 3rd, and August 14th, surgery is recommended. Surgery is completed by September 12th, and Dr. Scott testifies on September 19th. So all of the evidence that the applicant wanted to present was completed before Dr. Scott testified. It wouldn't have been that difficult to get those records from Dr. Letterman's office. He's easy to work with, and get them to Dr. Scott for his review and comment. Applicant's counsel elected not to do so, and I think by doing so waived any argument that the judge precluded him from developing the medical evidence by refusing to continue the hearings or take hearings from witnesses for whom subpoenas had never been requested. I'm looking at Amy. Amy specifically states, after reviewing the procedural rules, the following on page 392 of the decision: given compliance with the time limits. In other words, in Amy, the applicant had complied with the time limits, had submitted medical reports and evidence, had done timely subpoena requests. These procedural rules do not restrict the admission of relevant evidence at hearings. For example, in the present case, the claimant kindly requested a subpoena for Dr. Menick. The substance of his testimony was not restricted by the time limits or subpoena requests. So the procedural rules require you to submit subpoenas. They do not preclude your witness from testifying to events, medical records generated after the initial hearing. Amy rejects the argument that the appropriate remedy is a petition to reopen, noting, we have consistently concluded that the trier of fact should consider all pertinent data available as of the date of the hearing. The pertinent data was available as of the date Dr. Scott testified. Applicant elected not to have Dr. Scott consider that relevant evidence, and the matter was submitted. The defendants prevailed. I don't think under these circumstances that we can tell Judge Steiner that she committed reversible error by following the rules, precluding testimony from an expert for whom a subpoena had never been requested, and by taking testimony from the applicant's expert on the date that testimony was scheduled.
Mr. Baker, question for you on this. I'm looking at Rule 56 on the continuance of a hearing. Under subsection A, it says a party may request a continuance of a scheduled hearing. If a party shows good cause, a presiding administrative law judge may grant a request that the hearing be continued. I don't think, at least to my recollection, I don't think the ALJ addressed good cause one way or the other, either saying there was no good cause or there was good cause. Is that error? Did the court need to make some specific finding as to whether good cause existed or not?
Your Honor, I don't believe so, because I believe actually, and I know there's some disagreement from the bench on this, but again, I have to go back to Rule 41, and Rule 41 indicates that you don't continue hearings for witnesses for whom subpoenas have not been requested. And again, it talks about if a party timely requests a subpoena for a witness who fails to appear, the presiding judge may grant a continued hearing if the party requesting the subpoena demonstrates the following, but there has to be a subpoena in the initial instance. Now, I understand that this is not a circumstance where the witness failed to appear, but the witness failed to appear because the witness was never subpoenaed. So I don't think under those circumstances, if you don't request a subpoena for the witness in the first instance, the judge can't continue the hearing to take testimony from a witness for whom testimony has not been requested unless the parties agree to that. And the reason being is that, again, these cases are supposed to be tried expeditiously. They're not supposed to drag out over years. We try, generally speaking, to get really significant cases done within 180, maybe as much as a year, but we try to get the cases done expeditiously because the longer they hang on, the more they cost.
Thank you.
Mr. Baker, anything else for us today?
No, unless you all have any questions. We appreciate your time.
I'll look, and it doesn't seem like we have any additional questions. Thank you. Thank you, Mr. Baker. Mr. Wilmer, rebuttal.
Well, let me start here. In Superior Court, when you have a jury trial, you get one shot at it. And even in Superior Court, if you have a really good reason to make a late disclosure, you can do that. Things are different here. We have reopening. I mean, jurisdiction over this case exists until the petitioner dies, or even after they do a full and final settlement, there's probably still jurisdiction there. So we're in a different situation. But even, like I said, even in Superior Court, you can make a late disclosure if you have a good reason to do that. The ICA rules, specifically Rule 56, envision a litigant saying after the deadlines have passed or after an initial hearing, I have a new witness. I need a new witness. Here's why. I didn't know about it before. Here's the good reason why you should grant this. The rules also provide 155, I think it's E. Yeah, 155E permits a judge to suspend the requirements of a timely filing if there's good cause. So in this case, like I said, this is not about me getting my ducks in a row with my experts, et cetera. The cost of the IME was paid for by me, not by my client. She can't afford to do that. This came about because Dr. Katz, her family doctor, was concerned that she was developing a frozen shoulder. That's what led to her seeing Dr. Letterman. And with respect to Dr. Harmson, I did request a subpoena for him. It's in my April 2019 request. And as far as our stipulation about what evidence would be heard, that was between me and Steve off the record. And, the judge had made it clear that she was not going to grant the additional subpoenas. Mr. Baker objected to my offer of proof. He asked that those records be removed from the record, from the commission file. My approach was, okay, Steve, the judge doesn't want to hear this. Let's agree that we're going to limit our questioning to everything aside from what Dr. Letterman has to say. If I had tried to sneak Dr. Letterman's opinions in through Dr. Scott, Steve would obviously have objected, and the judge would probably have gotten irritated with me. So that's why we didn't get into that. I agree that the objective in litigating cases before the ICA is that they don't drag out over years. Here's where we are. We're up here at the Court of Appeals. I have a petition to open which is pending, which the commission does not have jurisdiction to act upon. Those are the records that I filed a motion to supplement this record, which included submission of Judge Powell's award, basically holding the matter in abeyance. So, what the judge should have done here is, and as I said, a new judge, we all learn from our mistakes. She knew my client was going to have surgery. That's big. It's not my client's going to get reevaluated by a new expert who's going to come testify. It's my client's going to get evaluated through a surgical procedure. The doctor's going to cut her open. He's going to look inside, see what's going on in there, and that may shed new light upon everything. It may change the opinions of the defense experts. And Amy speaks to prejudice. It's not, this is going to cost millions of dollars of additional work. It's, you can get a new IME. You're going to get that in a petition to open anyway. So in this case, I filed a petition to open. They had scheduled an IME. They got it canceled once we basically agreed that there's no jurisdiction to go forth with this. So to me, the judge made a wrong call. She didn't explain a reason for doing so. If she had granted the additional request for testimony from Dr. Letterman, we probably wouldn't be here. I may have still lost. I can't say I would have won, but we would not be here if she had done that.
Counsel, thank you for your presentations today. We appreciate it. You've given us much to think about. We will take the matter under advisement and will issue a written ruling in due course. With that, court is adjourned. Thank you much.
Thank you.
Thank you.